Good evening. This is Rahul Reddy from REDDY NEUMANN PC. Along with me is my business partner, Emily Newman. Emily, what do you have today?
So today we're going to be talking about the Trump administration's plans for employment-based immigration going forward, what to expect for upcoming regulations, a little bit about what to expect when you're dealing with driver's license renewals and immigration and how those impact each other. We know there was a recent bill passed in the House for deferred action. DACA, the Dreamers, that provides a path to citizenship. What can we expect from that? And we also are wanting to report to you that we have sued USCIS last week regarding what we've been talking about on here for quite some time about the delays we're seeing in H4 adjudications, which are delaying the H4 EAD. These are cases that were filed concurrently with a premium processed H-1B petition. The H-1B was approved quickly, but because of this new biometrics requirement, the H-4 has been basically pushed to the regular processing queue, even though the Immigration Service previously said they would be processed on a priority basis. So we have sued the USCIS on behalf of several co-plaintiffs and are already working on another case to prepare for that again. So we just want to give you some updates on that process and where we're at.
Emily, on suing the immigration for the H4 and H4 EAD delays, why can't you have requested for expedited things? Why can't you have waited until the H4 is approved? Why can't you have filed these applications before? Why do you have to go to the court, an expensive system?
Well, the main issue is, most of these people are filing well in advance. They can only file 6 months in advance, and 6 months is not enough time for USCIS to approve the H-4 in regular processing when processing times are 8 months. The whole purpose they paid this extra filing fee of the premium processing was so that they could not only get the H-1B approved, but make sure the H-4 and H-4 EAD got approved as well. The government is just not following through on its promises for processing these on a priority manner. Now, several of the people that have filed and are in this situation have done expedite requests. They have done service requests. And the answer is always, no, we're not going to expedite. No explanation given why their particular situation isn't considered to be worthy of that kind of relief. The service requests just say your case is being processed, or most of them actually say your case is within normal processing time, so we won't even accept a service request. These people are left with no other option.
Emily, so what is going to happen with the litigation? When did we file the case? What is expected of this, and how long it's going to take for those people who are in the litigation right now?
Yeah, so for this type of case, once the complaint is filed, the government has 60 days to respond to the lawsuit. So they typically will either reach out and try to come to some sort of settlement agreement, or if they want to fight the case, by the time they get to those 60 days, they have to file an answer to the court in response to the issues raised in the complaint. Now, a lot of employment-based cases never try litigation. It's kind of a new thing, and so it's new for the government too. They're not really used to being sued by employers and high-skilled workers for the government's actions or misactions. So many times we're finding that rather than fighting the lawsuit, they settle, and a settlement in our terms is to actually adjudicate the I-539 application, and once that's adjudicated, then they can approve the H-4 EAD. So the lawsuit, the purpose of it isn't, we can't ask for the approval of the H-4. All we can ask for is the adjudication, because that's what's delayed, and the idea is if everything's properly filed, it should be approved once they adjudicate it.
Emily, on the how long it's going to take right now?
To hear back on the lawsuit?
Yes.
Yeah, so we should hear back within the next 2 months from now.
Okay.
So that's kind of where we're at with the litigation front. Like I said, we are still accepting and reaching out to other potential co-plaintiffs. So if you're in a situation where you have already received the H-1B approval and the H-4 is still pending. You've got the H-4 EAD still pending. It's been, we would recommend waiting for 30 days from the time of filing before filing suit, because under the Administrative Procedures Act, the government has to adjudicate within a reasonable time, and Congress has set forth in the past that for non-immigrant visa applications, a reasonable time is 30 days. So we have to give them 30 days, but after that we can go ahead and sue if we're not seeing a quick enough result.
Emily, you have published an article on the Immigration Girl with regards to the Trump agenda on the employment-based immigration. There are certain guidelines that you have given on the proposed regulatory changes that are coming on the H4, that are coming on the H1B also, and also with regards to the lottery system, there are some regulatory changes that already occurred. Can you describe what is Trump administration trying to do on H4s right now? Where is the H4s there? H4 EADs, I mean.
So every spring and fall, the government has to put out its regulatory agenda. That's what is the government planning, what types of regulations over the next season or the next 6 to 12 months. So in the spring regulatory agenda, they did confirm, which we knew, that they are still planning to go ahead with removing the H4 EAD as an option. That is still pending with the OMB, but the government has all plans to move forward with that. In addition, we should expect a proposed regulation that is basically going to revise the definition of specialty occupation for H-1B, revise the definition of employer-employee relationship when it comes most likely to third-party placement or consulting type arrangements. They are expecting to increase filing fees again. We can expect them to potentially create a fee for the registration in next year's lottery. So as we know, this past April was the last time the H-1B lottery would be run, where everyone has to file full petitions and then they conduct the lottery and reject the ones that weren't selected. Starting next April, you electronically submit your registration, or the employer does. They run the lottery based on those electronic submissions, and only if you're selected then is a petition filed. So that should save time and effort and money, but it sounds like now that they're wanting to create a fee for employers to register.
Emily, now the driving license has been a major issue, Emily. There is a delay in the extension, especially for the H4s. People are complaining, I need to drop my kids out in the school, and the H4 extension they're not adjudicating along with the premium processing. A lot of other people also would require the driving licenses. What is the process of the driving license when the extension is pending? Is there a centralized process for the entire United States, or is it different for each state?
Yeah, it's going to be different for each state. So just depending on what your state's rules are, some states do allow you to renew a driver's license based on a receipt for a pending extension, whether it's H1, L1, L2, H4, EAD. Some states do allow that, but a lot of them don't. Texas is one that doesn't. So if you are not getting your extension approved in time to get your new I-94 and take that approval notice to the driver's license office, you may not be able to renew your driver's license until you get that approval.
So is there any solution for it, Emily, that you have?
No, unfortunately. Well, other than upgrading to premium processing for the I-129 for an H or an L approval to get that in time, but then we're stuck with what happens with the I-539 if they're not adjudicating that in premium processing when you upgrade, which that seems to be the case right now, and they're not expediting those. You know, what is your option? To go outside the country, get the visa stamped, and come back in just so you can get a driver's license? That seems a little bit ridiculous. It's just kind of the way things are going to be right now, I think.
We're having some technical difficulties for the YouTube, but Facebook is running good. Emily, on the DACA Bill, which has been passed by the House, you know, there are a lot of things that are going on in the press saying that, well, now It's passed in the House, so it's a law. Is it a law since it's passed in the House?
No, unfortunately, we need both houses have to approve that, and then it has to be signed into law by the president. So it's in the Senate's court right now. Typically, they would kind of create their own bill, and it might be different than the House's bill. If they were ever to pass it, then the two have to conference together to come up with a final bill, pass that, and then have it approved by the president. But what are your thoughts on the likelihood of the Senate actually moving forward?
While this administration is in their Emily, there's zero chance for this DACA bill to go through the Senate with the 60 votes that is required, and plus get it signed by the Trump administration. A zip chance, no chance for it. So at this point of time, I'm expecting no major immigration legislation is expected to pass both houses of the Congress. So nothing major changes are expected to come. But however, as you described, Emily, we are expecting the administration to have the regulatory changes, which they published it, what they want to do on the regulatory changes. But as such, I'm not expecting anything to pass through the Congress. Any questions, Emily?
Let's see here. I've got a question about updates on what's going on with the H-1B petitions that were filed in the lottery. Just to give you an update, we are getting approvals for those. Some big news on that is, as of yesterday, premium processing is available for all types of H-1Bs filed in the lottery. That means all types of H-1Bs, every type of H-1B right now, whether it's a transfer, everything can be filed in premium processing right now. So if you are wanting your H-1B to actually take effect from October 1st, you really may want to consider upgrading to premium processing. Maybe not right now, but I would say definitely if you haven't seen any movement on your case by August and you're wanting it to actually start on October 1st, consider premium processing to allow for the potential of a request for evidence. Because I will tell you that out of the petitions we've filed, we're currently at 25% receiving requests for evidence, which is about the same as last year. We're expecting that to continue to go up, considering that the overall RFE rate, I think, was 40% or higher than that last year, so probably going to be about like that this year. But that's where we're at on the cap subject H-1Bs right now from the lottery.
Okay, Emily, any questions from the Facebook?
Let's see, I'm having technical difficulties as well, but let's see what I can get here.
Sorry guys, our YouTube is off live today, but our Facebook is live. You guys can log into Facebook if you're listening to it, but we will copy this and paste it on the YouTube at a later time. Questions on H4 litigation, Emily, that I'm getting here is that how much does it cost to participate in the litigation?
Well, obviously we can't share legal fees, for every situation, every case in this means, but it's not as expensive as you think, and especially if you're able to join in with other co-plaintiffs on the court cost side, you're able to split those filing fees of the court and the process servers and all of that. So it is relatively inexpensive if you think about the thought of possibly losing a job or not being able to go to work or losing insurance. It's actually less expensive than going through all of those issues.
Emily, questions that came on the Facebook Live right now is the quota cases, he hasn't received the receipt notice yet. What are the probabilities he's going to receive it? Are we done with it? Are we receiving any more receipt notices?
Yeah, we're definitely not receiving more receipt notices. So if you haven't heard anything yet, unless your employer or the attorney is just slow in sharing that information or they don't share that information with you, more receipts aren't coming. You can have your employer check whether the filing fee check has been cashed or not. If it hasn't, then unfortunately that means you weren't selected. It's not possible for USCIS to still be cashing checks this late in the game. We're actually expecting probably next week to start receiving the return petitions for those that weren't selected in the mail.
Sachin has this question, Emily, is that does the officer has a discretion on how much longer the H-1B approval can be, or is it mandatory for him to give a certain period?
It is not mandatory for them to give the full period requested. You can request for up to 3 years total. But if there are not sufficient documents or the officer's not convinced that there's sufficient specialty occupation work available for the full time you're requesting, they may shorten the approval notice. That also comes up in the situation for jobs that require licensing and you don't have the license yet because of the way the state licensing works. In that situation, you'll often find that you'll get just a 1-year approval notice until you get the license, and then you have to file the extension after that.
Emily, one thing, 2 questions that came on the CPT and the Facebook, Emily, is that if there is an RFE on the CPT, what are the probabilities, how hard it is to address it? The RFE is about the CPT and maintenance of the status.
Yeah, I think it depends on the issue raised in the RFE. So last year, one of the most common issues was for those people who had completed a first master's, completed all of their OPT time, so they used 3 years of OPT, and then they go back to school for another master's and were issued CPT. USCIS takes the opinion that you can't get more practical training unless you go up a degree level. And for those types of RFEs, I have not seen success at all in that. So I would typically recommend thinking about converting it to consular processing to avoid a determination that the CPT was a violation of status. The other type of kind of common CPT RFE is about whether it was properly authorized during the first year of graduate studies. How is it essential to the program? And then they ask for you to prove that you are attending classes, so they want to see letters from the registrar, receipts for tuition, receipts for books, how were you getting there, when were your classes, transcripts, all of those sorts of things. I would say those type of RFEs are kind of a 50-50 chance of approval, depending on the school and their documentation, and then just depending on the officer.
Question from Bhargav from Facebook is that he has a STEM OPT H1 and his H1B is approved. Is it right time for him to switch the employer? No, this is not the right time for you to switch with the employer. I'm assuming that this is a new quota, which the approval date is October 1st of 2019. The right time to switch for you is on or after October 1st to a new. Because if you switch right now, your existing company may withdraw the H1B. That means that you may have not been counted towards the H1B.
Harish has a question from Facebook and wants to know if we can file the H4 EAD while the H4 is still pending because of the biometrics. The issue with that is in the instructions, the USCIS says that if your H4 is pending, they recommend waiting until it's approved before filing the EAD. The reason for that is in the EAD application, that officer is a different officer. They may not have access to your H4 application to know whether it's approved or not. So very likely when you file your EAD using the H4 receipt, you're going to end up with an RFE asking for the H4 approval notice, which is going to delay the EAD by another 60 days. So you really have to think about, is it worth delaying the EAD and filing it earlier, but then delaying it by 2 more months, or waiting maybe 1 or 2 months for the H4 to get approved and then filing the EAD after that.
Robert has this question. He was on H1B from 2016 to 2018, and he got his H1B selected in the lottery. Will his 2 years on L1 be counted towards the H1B 6 years limit? Robert, yes, it will be counted towards the H1B limit. Because for you to move from L1 to H1B and not counting the L1, you must have stayed outside the country for 1 whole year before entering back on H1B. So in your case, you entered back on 2018, in 2018 itself, you got the H1B, so you were not outside the country for more than 1 year, so that 2-year period of H-1B will be counted. You may want to file the labor and I-140 application, Robert. In that way, you can extend the H-1B after your 6-year limit, including your 2 years of L-1B. You can, once you apply for the labor and I-140 approval, you can extend the H-1B beyond 6 years.
Sarah has an H-1B extension that is pending. It was filed timely before the I-94 expired, but also has a pending I-485 application and wants to know what impact an H-1B extension denial might have on the I-485. Short answer is it depends. If the 485 was filed before your I-94 expires, the denial of the extension should not impact your ability to adjust status because you were maintaining your non-immigrant status at the time of filing. The big thing to worry about in that situation is once the H-1B has been denied, if you don't have your EAD yet, you have to stop working until you get the EAD card in the mail because you don't want to have unauthorized employment while your 485 is pending. Now that being said, if the H-1B extension was timely filed, but the 485 was filed after the I-94 was expired based on the pending H-1B, and then the H-1B gets denied, depending on the timing, because the pending H-1B is not considered for you to be in H-1B status. It's considered period of authorized stay, and the 485 requires you to be in H-1B status at the time of filing. So if the H-1B is denied, that time you were in the period of authorized stay doesn't count for purposes of filing the 485, and it could be problematic. So it all depends on the timing of when the 485 was filed and when your I-94 expires.
Question came from Facebook with regards to his wife is on H4 visa, but now she got the EAD, and if she travels outside the country, will she have any problem at the port of entry because she has the H4 EAD now? No, we're not expecting any problem. She is married to you and she has an intention to work also. There's nothing wrong with it. We're not expecting any problem at all in the port of entry.
Ram says he joined the current company in January after getting his H-1B approval, but at that time no application was filed for his spouse's H-4. How do I check my spouse's H-4 status? So I'm a little bit confused on what type of H-1B was approved in January. Was that a change of status? And if so, if no H-4 change of status was filed for your spouse and the spouse is not is in the U.S., then you may have a problem because the H-1B does not do anything for your spouse's status. That's a separate application. If your spouse is outside the country, then they just need to take your approval notice and apply for the H-4 visa at the consulate. So really a little unclear on what the issue is there.
I have a question from Facebook. He's an H-1B. Can he do the Forex trading? Will that cause any problem? No, sir, that is not a problem at all. You're just trading, you're not working. So we don't expect that to create any problem whatsoever at all for your H-1B.
Chirag has the question of the day. How much is the wait time for getting the H-4 and EAD approved if it's filed with an H-1B that uses premium processing as of right now? I can tell you, since the biometrics came into effect March 21st, we have yet to receive any H-4 approval.
Not a single one yet.
So that tells you since March, April, May, June, we're going on 3 months with no approvals, even though the H-1B was filed in premium processing.
Question is on the 485, how long it's taking for the persons whose prior date is current to get the green card once the 485 has been filed. It is taking anywhere between 12 months to 18 months if the prior date is current to get the green card. As you may already know that from March of 2017, all the 485 applications that have been filed require to be interviewed before they are being given green card. If you look into the, Emily, I want to have some of the discussion with regards to, since the Trump administration came, there are so many different changes they have done. I think so all of them are to delay the process. One thing is to have the adjustment of status interviews for the employment-based. Now we have the social media right now that came out about 3-4 weeks ago. Now the H4 stamp, the fingerprinting for the H4 and also for the F1 visas. Don't you think all this is just to delay the cases?
I'm sure they won't say that. They're saying they're making America secure, but certainly that's the effect that it's actually happening. And I do think that that is kind of an underlying motive.
Agenda for it. And also, if you look into, there was a Forbes article published yesterday, Emily, with regards to the H4 EAD, the way they are actually denying, they're not denying the H4 EADs, they're delaying it, and they're not giving the H4 EADs by delaying it. It's a nice article that came on H4. So the whole purpose of this administration seems to be what they cannot do it legally, they're trying to delay it. By delaying it, they are trying to deny it.
Question on H-1B specialty occupation RFE. What kinds of documents can be submitted? Well, usually the RFE gives you a pretty long list of items that can be submitted to prove specialty occupation, so definitely take a look at that. And I also have a post on immigrationgirl.com about specialty occupation and the 4 criteria that USCIS uses. But they're looking at the Occupational Outlook Handbook. The employer may be able to provide proof that they normally require all of their employees in that type of job to hold at least a bachelor's degree in a specific field. So for that, they would be submitting the bachelor's degrees of those other employees and their payroll records to prove they were actually employed. You might be able to provide proof that other companies normally require a specific bachelor's degree for the similar job. So that can be done by looking at job postings online for different companies. Just be aware that the company has to be similar to what your company does, similar in size and scope and nature. So a lot of times, even if you have those documents, the immigration officer may just disregard them if they think the company is not similar to what yours does. A lot of times you can obtain an expert opinion letter from a service that can, or a letter from a competitor company that says, yes, we also normally hire this type of position, and for our company, we require a bachelor's degree in a specific field of study for similar positions, or a service can provide that. A lot of times the immigration service kind of tries to disregard these expert opinion letters on the ground that the professor who is giving the expert opinion doesn't know enough about the company, never visited the company, or never talked to the company. So there are some services that have an interview component to them creating this expert opinion letter. I would recommend that type versus a kind where there's no interview requirement. So, but again, definitely check the request for evidence because it will have a long list. Detailed job description is also probably the #1 thing that you can submit.
Harsh has this question from Facebook that he is staying extended period of time on H-1B. His payroll is still continually running on on the U.S. taxes. Will it cause any problem for him to extend the H-1B? If you're working in India, you must be subject to the Indian taxes. The Indian government may impose tax on it. You may end up paying the taxes in the U.S. and you may end up paying taxes in India too. So you may want to check with your CPA on that. If you stay in India and you're getting paid in India, you're paying the Indian taxes, it won't be a problem when you extend the H-1B, but of course the USCIS will look into the intent. What is your intent to have an H-1B? Is that something that you want to have it as a fashion to you, H-1B, when you're actually working in India? Or is it that what is your intention will be tested at the time when they're extending it, at the time when you're consulate visa, at the time when you're entering into the United States? They don't want people to enter into the United States on wrong visa. If your purpose is only to come and solicit some business and then you want to go and work in India, B1 might be more appropriate for you. So the intent why you're working on a long-term in India need to be clarified, Harsha, before we can evaluate more. But I would say that that definitely might be a tax violation, of Indian tax violation though. And also, U.S. might not have that much objection because you're paying the taxes here, but Indian government may have objection. Now, if you really want to work in India for a company here, technically you don't need to have a H-1B at all. Absolutely, you don't need to have any work visa to work from India to a company here, because US government and the Indian government, both governments do not recognize cyberspace as a space. They only recognize where you're sitting. That is a space that they recognize.
Satish has a common issue that comes up. His son's I-94 was shortened when he entered the last time because his passport was expiring before the visa or the approval notice was expiring. So once he gets the passport extended, what are the options? So option one could be to visit CBP's deferred inspection site and request them to provide an extended I-94 by showing that the passport has been renewed. This is very inconsistent. Some CBP locations will do it. Some say, no, it's your own fault that you came in on an expiring passport, so we're not going to do it. Another way to correct it is to travel again with the new passport, assuming you have a valid visa and can come back in to get the full period. Another option, not a great one, but you can file an extension to get the I-94 extended. In his particular situation, he's asking about a cruise, if that's an option, and it could be. Depends on the cruise. I mean, if you are leaving from a U.S. city, going to Puerto Rico, for example, and going back to a U.S. city, you've never actually left the U.S., so you might not be given a new I-94 when you come back in to the port. So if you're going to other countries, then there would be some sort of CBP inspection upon your return to the U.S. that would likely give a new I-94.
Question from Con. If the H4 EAD extension is pending, what do we do with his company that has operations right now and the EAD expires?
You need to have someone else take care of it until you get your work authorization back, because you're unfortunately not authorized in between. That's not a good situation.
Varun has this question on Facebook. Can you share the Facebook conference call details? We do have a daily conference call at every day, half an hour. It's free. You guys can directly call in and ask questions. You'll be in line to ask questions, of course. The conference call details are at rnlawgroup.com. Every single working day, we do conduct a free conference call, Varun. You can check the details at rnlawgroup.com.
Shash wants to know what's the time frame for a Freedom of Information Act request to get the I-94 receipt number. So this is something where if your situation, your employer's not sharing documentation from your I-140, such as the approval notice, so that you can file an H4 EAD, for example, or you just want it for your records, you can go to USCIS and file a Freedom of Information Act request and get a copy of the I-140 documents that were filed in your case, and it usually has some stamps on it that'll have a receipt number, and you can use that as proof of the I-140 filing. As far as the time frame, the government shutdown that happened, when was that, in January, I think, caused a lot of delay in that, and so since the shutdown, I have not received a FOIA request back from USCIS. I will say from CBP, I had done one in November and just got it back maybe a week or two ago. So it is not a fast process. I would plan on at least 6 months.
Ramon from Facebook has this question. He is transferred from company A to company B. Company A's I-94 is expiring in 2021. His wife's I-94 is also expiring in 2021. Company B did not file for the H4 application for his wife. Is it a cause for concern for him? Should he be worried about? No, you don't have to be worried about it. Your wife's H4 I-797 is valid until 2021. So you don't have to file for the H4 extension right now. You can wait. But you need to file for her H4 extension before her I-94 expires, which in your wife's case is before 2021, whatever the date the I-94 is expiring.
Naveen's spouse has an H4 and H4 EAD in process. She also previously held an H-1B in the past and wants to know if there'd be any issue if she files an H-1B petition as well while the H4 and H4 EAD are in process. It depends. So if the current H4 has not yet expired, she can file a change of status from H4 to H-1B and it's not dependent on the approval of the H4 extension that's pending right now. No issues with that. If her H4 has already expired, that means she's not actually in H4 status right now. She's in a period of authorized stay. You can't change your status from a period of authorized stay to H-1B. If you file that change of status, you'll likely get a request for evidence asking for the H-4 approval notice, which is going to delay the whole case. So it really depends on whether the H-4 has expired or not. But the follow-up question to that is, what if they're both approved? I get the H-4 approval, I get the EAD, and my H-1B gets approved. What happens? Kind of depends on the timing. So assuming that the H-1B is approved first and then the H-4 is approved, there is the last action rule, which would suggest that she's back in H-4 status and just undid the H-1B. If the H-4 gets approved first and then the H-1B, well, then she's in H-1B status. If she may be able to travel to clear that up, to when she re-enters, she's going to have to show one approval or the other, and whichever one she shows to the officer at that time, that now becomes the last action, and that will be the status that she's in. So it's not a huge issue because it can always be cleared up by travel if they happen to get approved at the same time.
Siddharth has this question: does the RFE, does the premium processing increases the chances of getting an RFE, especially is in the second master's degree? I'm not going to comment on the day one CPT at this point of time, but let me tell you this, that just because you file in premium processing does not increase or decrease your chances of getting an RFE. It is the same, nothing different.
Srikant wants to know, is it an option, is it better to file the H1, H4, and EAD altogether in premium, or file them in regular and then upgrade to premium after the biometrics are done? We still don't have feedback on our test case where we have filed in regular and are upgrading, because the biometrics are still in process for that. But once we do, we will let you know if that solves the issue. We have a feeling that it's the plan of USCIS to no longer process the H4 along with the H-1B, so that may not solve the problem. So stay tuned. We'll let you know as soon as we find out a strategy that actually works on that, if there is one.
Robert has this question that his H-1B is stamped in one passport. Now he's actually gained a citizenship from a different country. Does he need to get the passport stamped with the new passport that he has? If you are a dual citizen, which some countries do allow, for example, Pakistan and Canada, they both allow dual citizenship. So if you're a Pakistani national and you become a Canadian national, yes, you can use the old passport of Pakistan with the H-1B stamping to come into the United States. But when it comes to the India, for example, they don't allow the dual citizenship. So if you have a passport stamping on a country that doesn't allow the dual citizenship, as soon as you took the citizenship from the other country, this passport, you have to return it to the home country. So that passport should not be with you. Hence, you cannot use that passport. You need to get the stamping on your new passport before entering into the country. But if the dual citizenship is allowed, you can use your old passport with a different country and you can enter into this country. But if the dual citizenship is not allowed, you have to get the passport stamping in your new passport.
Bhavya is planning on getting married and wants to know if after she gets married, I'm assuming this is going to be outside the U.S., she can come back on F1 and complete her OPT after she's married. Again, my short answer for everyone today is it depends. Do you have the valid F1 visa stamp? If you do, then that should be okay. If you don't have the visa stamp, it's possible that when you apply for the F1 visa to be able to return, you might not get the stamp because you've already completed your studies. The purpose of you entering now is not to study, it's to work. So that may be difficult to get that stamp. And I guess it would also depend on your spouse. Is your spouse a U.S. citizen? Is your spouse a green card holder? Or no, not in the U.S.? I mean, if your spouse is a U.S. citizen and you're trying to come in on an F1, that's probably not a good option. They're likely to say that you are an intending immigrant and your plan is to obtain the green card now that you're married to a U.S. citizen. So it kind of depends on a few factors there.
Siddharth has this question. His wife came on F2 visa, and when his H1B has been converted, his wife got H4 visa. Now she wants to convert to F1. She has a problem if she goes for an interview with F1. Yes, there's a good chance that she might have a problem when she goes for the F1. The reason is that, as Emily was pointing out, the intention of the person to come into the United States. She was given a non-immigrant visa, she changed the visa, and now she is trying to change back. What is her intention when she comes into F1? Is her intention to study, complete, and go back to her home country, especially when the husband is working on H1B? Or is it she comes and she plans to convert into H1B at a later time? You might have a tough time getting the F1 visa because the intent, the consulate might have a problem. Now, that intent might not be an issue when it comes to the H4 visa, because H4 visa people can have a dual intent. One intent is to temporarily go, the other intent to settle in the United States. That's not a problem in getting the H4, but that is a problem for F1 visa.
Tanu Priya wants to know why the receipt notice for the I-140 petition does not reflect the priority date that they're trying to recapture. So if you already have an approved I-140 with a former employer, for example, and you're filing a new I-140, you can retain the priority date from the old so that you don't lose your place in line. You do that when you file the new I-140, you request that the date be ported. Now, the receipt notice, when that's generated by USCIS, they've not looked into the actual I-140 petition at all. So they're not able to see in the mailroom when they're doing their data entry that you are requesting to port your priority date and that you have the actual qualifications to do that. So they're just going to either leave the priority date blank most of the time on the I-140 receipt, or they're going to list the priority date based on the labor certification you're using at that time. It's not a problem when the approval comes, assuming the request was made in the filing, it will come with the old priority date on it.
Pawan Kumar has this question from Facebook that he filed H1B, H4 plus EAD. His H1B is approved right now. Can his wife go to India to get the H4 stamping while the H4 and EAD is pending? Yeah, she can go to India and get the stamping. Her EAD will be denied. Her H4 transfer or extension will be denied. But based on your H1B, your wife can get the H4 stamping. Absolutely not a problem. Once she comes here, she needs to apply for the EAD because the EAD that was attached to the H4 will be denied, because once you leave the country, the extension or transfer is considered to have been abandoned. And that's the reason that will be denied. Once she gets the H4 stamped in India, she can come back and get the EAD approval. Now, for her to get the H4 approval in India stamping, she doesn't need a I-539 or 797 for the H4 approval for your wife. She just needs your H1B approval.
Andy has a question currently on OPT cap gap, waiting for the H1B to be approved, and wants to know if he can transfer these SEVIS to higher studies before September 30th, which is when the cap gap ends. So yes, you can do that, but be aware that when you get that new I-20, your cap gap ends. So you have to stop working from that point unless your school, the new school, authorizes you for some sort of employment authorization. And then driver's license expired. How do I get my driver's license renewed when you're on the cap gap? Some places might not do it. You should be able to do it using your new I-20 that authorizes your cap gap through September 30th, but I know in the past several people in Texas have had a problem with that. Obviously it's different for each state, but the I-94 plus the I-20 authorizing the cap gap and probably your expired EAD and your passport, all of that combined should be accepted, but sometimes they're just not familiar enough with all these different statuses and extensions, and they may refuse to renew.
Gary has this question. His H1B has been approved. It's been 7 weeks. He didn't receive the H4 receipt notice. Gary, that looks very odd. For 7 weeks, you don't receive the receipt notice. That's what you say in the Facebook, but I'm not sure. Is it the approval that you're speaking, or is it the receipt notice? If it's an approval that you're speaking about, that looks reasonable. But if it's a receipt notice, a 7-week, that's unreasonable. And most probably somewhere it's been misplaced. You may have another alternative to check on the check that was sent with the H4. If is it cash? If it's cash, you are in a safe zone. But if it's not cash, you may not be in a safe zone. You may have to refile the H4 application. So the clue here would be for you to detect whether or not the H4 check has been cashed.
Prashant wants to know about the 60-day grace period. So there are 2 different types, so I'm not sure which type you're referring to, so I'll do a quick overview of each. There is a 60-day grace period following your F1 status. So the typical situation is you come into the U.S., on F1, you receive an I-94 that's valid for duration of status, you complete your studies, you get your OPT, you get your STEM extension. At the end of your STEM extension, assuming that you're not eligible for CAP-GAP, you then have a 60-day grace period. During those 60 days, you can wrap things up to prepare to depart the U.S. You can enroll in a different program of study to continue your F1 status. You can file a change of status to any other type of visa that you may qualify for. So that 60-day grace period, you are considered to be maintaining your F1 status. So that's one. The other 60-day grace period is if you're on a work visa, such as an H1 or an L or a TN or an O, and your employment terminates for some reason. Either you resign or you were laid off or whatever the reason is, you may be eligible for a 60-day grace period that allows you to transfer to a new employer and get that transfer petition filed within 60 days. If it's filed within 60 days, you're considered to have maintained your H1 status the entire time, even if you were not working for part of that time. Now, the 60-day grace period can be cut short if your I-94 expires in less than 60 days, or if your I-94 has already expired, and maybe, say, for example, you had a pending extension and your I-94 expired and then the extension got denied, there is no 60-day grace period that would allow you to file another extension or file a change of status at that point.
One question is that can 2 companies file LCAs for the same location and file for the H-1Bs for the same location? That doesn't look good, because the question is whose job it belongs to. If the 2 companies are saying the job belongs to them, the question that comes is whose does it belong to? Why are they filing the H-1B? So if you put both the applications together, they are conflicting with each other without even taking a look into what the law is, because both of them are telling the job is theirs. So that may not be appropriate for 2 companies to file the H-1Bs at the same time.
One of the questions from Facebook was received an audit on a labor certification and the documentation has been submitted. How long does it take to get the approval? So the processing times for audited cases they're available online. And so right now they're processing audit responses for cases that were initially filed back in November of 2018. So it adds about an extra 5 months to the processing time if your labor certification has been audited. On that note, I want to mention that there is a new system that went into effect yesterday with the Labor Department. As of right now, it is for prevailing wages that are used in the PERM filing. Instead of submitting prevailing wages in the old ICERT system, now we have to submit them in the new FLAG system, Foreign Labor Application Gateway. So this is a brand new system. It's got some kinks in it, so just be aware you may face some additional delays in getting prevailing wages. Their processing times are quite long already. It's, I think, 4 to 5 months right now to receive a prevailing wage. So that might actually increase just with this transition of switching from ICERT to FLAG. And this new FLAG system is being rolled out eventually this fall for the LCA system used by H-1Bs as well. So it's kind of the Labor Department's next version of digital processing of applications. Hopefully it'll eventually reduce processing times, but just in the transition, there are always some hiccups that happen.
Mohammed has this question with regards to, he's on the 485, his EAD is approved. Can he work for a different company than the company that filed for his green card? Assuming that your I-140 has been approved, assuming that it's been 180 days since you filed for your adjustment of status, you can work for a different company, but that different company need to file a application called 485J supplement and file it with the immigration. Not only they should do it, that the other position that you're joining should be similar. Doesn't have to be exactly same. Should the new position that you're going to be working should be similar to the previous underlying adjustment of status application, whatever the position that they have described, the new position should be similar, and the new company should be willing to sponsor application form called 485J supplement.
One of the questions on Facebook, I think it was Krishna, asked, is there any chance that the employment-based green card process for the priority dates, will there be any significant movement forward under the Trump administration? No. To actually see some positive change in the visa bulletin would require Congress to change the laws. So one of the things is to remove the per country limit, the 7% cap. That is a proposed bill right now. I think it finally hit 200 or 300 co-sponsors yesterday. So it's a very popular bill. It's in the House, though, and the Senate never seems to, first of all, the House bill never actually gets to the floor. No debate has ever been done on it. We don't know if they're ever going to pass it, but even if they do, is it likely that the Senate is going to take it up either? Probably not in the current situation. If you want predictions for where the dates should move over the next few months between now and October 1st, I do have a post on that on immigrationgirl.com. So what to expect in the upcoming visa bulletin. It doesn't look good for EB1. It's going to continue to be backlogged. EB2 and EB3, same story. There's not a lot of
EB1 is backlogged for Chinese nationals, but EB3 is currently.
Right, yeah.
Now, coming to the point on the blame that our audience has said on the Trump administration, the backlog system actually has nothing to do with the Trump administration, though. It has something to do with how the legislation has been passed about 30 years ago, and they never cared to bother to change that legislation, but nothing much to do with the Trump administration. Having said that, to add to the things of what Emily has pointed out, there are certain things that the administration can do to make the priority date current if they want to. This administration definitely doesn't look to be, but if they want to, they can not count the family members. Now, let me tell you an example. In the H-1B, only the main applicant is counted. The dependents are not counted. The H-4 are not counted. When it comes to the employment-based 140,000 green cards, even the dependents are counted. So practically out of 140,000, only 60 to 70,000 are given to the employment-based, and rest of the people are dependents. So if they don't count it, from 140,000, it will go to about 300,000. That will eliminate most of the backlogs in the next 2 to 3 years. All the backlog will be finished. That's one way they can do it. The other way they can do it is that between 1992 to 2003, they wasted about 250,000 green cards, because back in the old days, even when there is no demand from the other countries, there is no rule that they can give those wasted green cards to the for demand countries, for example, India and China. So between 1992 to 1993, instead of giving 140,000 green cards every year, they gave very less green cards, and that amount is 250,000 green cards. If they come and release the 250,000 green cards, the administration can do, if they want to, that might get the priority date current. Yes, I would then say that yes, this Trump administration is not doing it. But with regards to the priority date as it is going on, it is not just to Trump administration to be blamed.
Rakesh has a question regarding the transition from OPT to H-1B. So he's got the STEM extension right now, and his H-1B is still in process, and his employer is telling them that he's not eligible to work from August until the H-1B start date. So it depends on whether your H-1B requested a change of status from F1 to H-1. If it did, and your H-1B was in fact selected, then you should be able to take that H-1B receipt notice to your school DSO and request an updated I-20 that extends your OPT to September 30th for the cap gap, and show that I-20 along with your expired EAD to your employer so that they can continue to employ you through September 30th. Now, if your H-1B requested consular processing, the cap gap doesn't apply. So if your OPT is expiring in August and your H-1B is not going to start until October, you can't work beyond your OPT expiration. You have the 60-day grace period to leave, get the H-1B stamped at the consulate, and come back into the U.S. on or after October 1st in H-1B status.
Before finishing the closing up this one, I want to answer Abhishek Gautam's thing. Abhishek Gautam is asking, is there a light in the end of the tunnel for those people who are actually waiting for the green card from India? Abhishek, I have to tell you that unfortunately, if the things remain, unless the legislation changes, which looks to be very unlikely under this administration, because there were legislative changes that the previous administration tried to bring in, the Clinton administration in 1990s, the Bush administration in 2000, and Obama administration tried to bring in the legislative changes they couldn't bring in. This administration doesn't even try to bring in any changes. So Abhishek, I want you to plan your life accordingly, whatever you have to do with your family, that you're not going to get the green card here ever. I want you to plan your life. Maybe if something pops up, that's fine. But if not, I want you to plan your life that you're not going to get the green card in USA. Anything else, somebody?
One last question we can take from Facebook regarding the new DS-160 questions asking about social media. So in this situation, the person has submitted the DS-160 before the form changed and wants to know if now that they've added that question, do they have to go back and correct it or submit a new one? No, you don't. So the new question about social media is only for those who have not yet submitted the DS-160. If you've already submitted it before that question came in but haven't had your visa interview yet, you don't need to take any action.
Thank you guys for tuning in. For those people that we couldn't answer, you can come to our daily conference call. You can subscribe to the news section in rnlawgroup.com. You can also subscribe to immigrationgirl.com, which Emily manages it. You can also make an appointment with me, Emily, or any of our colleagues. Our schedule is online. You can go to RN Law Group and make an appointment with me or Emily or anybody else in our office. Anything else?
Thanks for joining.
Thank you.